with expert assistance and guidance related to state authorization and regulation of higher education institutions, state institutional license application review, as well as state-level professional licensure. She at one time was also one of us. Before joining the higher education practice, she served as a licensure manager and education policy analyst at the Florida Department of Education's Commission for Independent Education. Next to her is Brianna Bates. Brianna serves as the Assistant Director of Academic Program Review in the Office of the Provost at New York University. Her unit within the office is responsible for spearheading any necessary non-New York state approvals and for supporting new program registration and monitoring program changes with the New York State Department of Education for over 1,000 academic programs. Next to her is Gregory Ferenbach, who's a special counsel in Cooley's regulatory education practice and resident in Washington, D.C. office. He advises educational institutions and technology companies on education law matters at the federal and state levels with an emphasis on issues arising from online learning. And next to him is my neighbor, or former neighbor to the south, Alan Contreras. I would suspect, if not the majority, all of you heard Alan's bio earlier today. He's kind of hogging the program because I get to introduce him again tomorrow. As you may recall, Alan worked for 12 years as the head of the Oregon Office of Degree Authorization, also for the University of Oregon, Oregon Community College Association, and the Missouri Coordinating Board of Education. He's also an accomplished author. He mentioned one of the books he's collaborating on, books including College and State, Birds of Oregon. I always rely on Alan. I will call out and say, Alan, this bird is eating at my feet, or what is it? Because I narrow them down to big birds, middle-sized birds, and small birds, but he can actually define them a little better. He's also read...
You can also do edible versus inedible.
Yeah, well, I don't get that far down. And this was not on his official bio, but I believe in one of my conversations with him, he mentioned one of his aspirations is to be a science fiction writer. And when he said that, the immediate thing that popped into my mind was, Alan, that puts you in good stead for your current function of being a SARA consultant as well.
Oh, that's low, Mike.
I want to thank the panel and look forward to your presentation. I get only so many chances, Alan.
It's a plain hat, plain hat.
All right, let's see if we do have it. All right, last night at the reception, Crystal Putera said that when we turned in this presentation and I know I did this part, she said that the gaps were all capitalized, so she wanted to know what that stood for. And I'm sure it just meant that I had the Control-Shift-Lock on. But I thought, I better think of something quickly. So I decided that the G will stand for G, I love SARA. The A will stand for alternative providers, which we will talk about today. The P will be professional licensure, which we will talk about. And the S will be for some other stuff. And we'll talk about understanding the federal overlay and the international issues. So we haven't covered the gaps, whether they're all capitalized or not, and that will make me feel better, and I'll let Crystal know that as well. All right, so let's talk about what SARA doesn't apply to. And if you're a non-degree granting institution, you're not part of SARA. Now, in saying that, if you're an institution that happens to have a degree program and you're also offering non-degree, those non-degree programs are covered. So it really does mean if you are solely a non-degree granting institution. If you are not accredited, then your institution will not be part of SARA. And the great news is accreditation is whether it's national or regional. You will be covered if you are either of those. One of the biggest areas that institutions are needing to pay attention to if you're a SARA institution is don't forget those professional licensure boards. So whether you have nursing programs or programs that will require a teacher license on the back end, social work programs, psychology, counseling, the allied health programs, any of those that will lead to a licensure once that student graduates. For the professional board itself, those requirements are completely independent of SARA. So once your institution has met its requirements to participate in SARA, you still need to talk to those other boards, make sure you're doing what you need to do to make them happy, because some of those boards still don't know SARA. Let's talk about the alternative providers, because as we all know, the last few years we've heard a lot more about them, and we're talking whether that's MOOCs or boot camps. There's been quite a bit of press lately about coding camps. A lot of times those may be coming out of an institution that doesn't have degree programs, so they're not going to be operating as a SARA institution. So those are other examples that would fall through the cracks, or the small group that are participating in the federal EQUIP experiment. Again, to bring those alternative providers in for federal purposes, but remember, even so, that does not meet the state purpose. So the state can still say, well, that's great that you might be under this experiment with the federal level, but for our purposes, you still need to do what we're asking of you. Some states have exemptions for alternative providers, so you may be able to be okay in the state that way, but you definitely need to make sure that you fit in one of those exemptions if you see yourself, or should see yourself, as an alternative provider. Also note that one thing that's happened as more states have added SARA, they've changed their regulations. Now, not all states have done this, but many of the states have actually altered their regulations so that they align more with SARA. So states that used to require a physical presence trigger in the state have become a purely online state. So simply offering programs online are enough to require authorization in states where that did not used to be the case. So we're up to about 15 states now where simply offering online does require authorization. So if you are already not a SARA institution, you need to pay attention to that. And again, if you're a non-degree institution, you would look at all of the states that are on this list and know that in some form or another, you would need to get some form of either registration or authorization, or in the case of Georgia, you submit a letter and they look at that to verify that and then give you an approval based on what your activity is or is not there. But again, it's a fairly long list that you need to pay attention to. All right, let's look at professional licensure. Again, remember that their rules are separate from what the higher ed agency is going to require. And also, sometimes they don't always work hand in hand. In fact, it wasn't that long ago that a lot of the agencies really didn't talk to each other at all. It's gotten better in a lot of states where they really do talk a lot with the professional boards, but sometimes I know that I will talk to a board and they're not even familiar with who the higher ed agency person is, who might even just be down the street or sometimes even in the same building. And because they don't always work hand in hand, a lot of times one will say, well, we'll approve this part of the program, but I think you need something from that other agency. And so again, it'll be important to know what it is you need from whom. And what does happen when that professional licensure board is not happy? Well, we have seen, and once in a while you'll read about something, but oftentimes you won't, that a student will graduate and it turns out that their institution has not met the requirements for the professional licensure side of things. So guess what? That student will not meet the requirements for professional licensure and will not get a license. And things don't go well at that point. You have unhappy students, then the institution isn't happy, the state's not happy, and you'll see, like I said, once in a while you'll read about that, but more often there will be something that goes on behind closed doors, so to speak, and a settlement will occur, which will result in either returning of the, well, it's usually more than, but a returning of the cost to the student as well as the time the student spent there. So another thing that to look at is requirements for federal misrep at the federal level will need to be met, and Greg will talk more about the federal requirements a little bit later. Note too that just as with state authorization, big surprise, professional board requirements vary greatly from state to state. Some are going to be very specific in what they mandate. Some states will say, if you meet the teacher requirements in your home state, we'll accept that as long as you're regionally accredited. Different states will put different levels of what they require on that. Sometimes they'll say, yes, you may transfer a license from your home state into our state. However, before you can do that, you will need to increase the level of field experience that you're bringing into the situation. Or we may require 15 more hours in a certain subject area than your home state did. So it's not always an automatic fit going from state to state. So as an institution, it's extremely important that you pay attention to that when you're reaching to students in another state, because your state may be perfectly happy with how you're doing it, but another state may want more. In fact, some boards won't even approve an online program at all. Kentucky will say no to your teacher education program that's online. And other states will not allow a transfer license until you meet additional requirements, even if you're part of a reciprocity agreement. And I'm speaking about not SARA in this case, but such as a teacher reciprocity agreement through NASDTEC. They will say, yes, you can transfer a license. All the states have signed up for that. However, they have a right to add additional requirements on top of that. So it's extremely important to be aware of those. And now I'm going to hand it over to you, Brianna, to talk about the international issues.
Thank you. So a lot of you were with us last year when we became aware of some new international issues in the industry, and specifically courses being offered by our institutions to students located in international jurisdictions. And what does that mean for us? Do we need to do anything? And the answer is yes. There are regulations we need to be aware of. There are things we need to comply with. NYU partnered with Cooley to purchase an initial report that they did of 12 priority countries to begin to grasp that landscape. And that's been really helpful for us to see if we need to seek accreditation with a specific national accreditation entity in another territory or location. A lot of times there are implications related to tax, whether it's income tax or VAT tax related to the tuition that you're collecting from the international enrollment. And from an institutional perspective, we've been able to kind of look at where our enrollments are coming from and triage from kind of a hierarchy related to most enrollments to least enrollments, and change some of the enrollment agreements, change some of the language that the students are seeing so that they're aware of certain taxes that could be levied or are levied, or that they need to remit or we need to remit on behalf of the enrollment. So that's been really helpful to kind of take into account specifically for our purely online placements. As you know, NYU is very global, so we also have many global sites that we work with, and we have certain requirements we have to do there when we have a building or a partnership with a university. But a lot of times, even to go into a partnership with an existing university that's located in a foreign jurisdiction, there are regulatory requirements that it's important to be aware of. So a lot of times a basic MOU that we thought a couple years ago was okay because you agreed with everything that was listed and general counsel signed off. A lot of times there's some other things you need to be aware of and consider to embed in that MOU to make sure that everybody's compliant and everything's transparent for both institutions and the students involved. Do you want to add anything to that, Greg? I know you have a lot of international.
Maybe when we get to our discussion.
Great. The next, oops, sorry, I went backwards. Okay, so now I'm just going to talk about, from an institutional standpoint, minding the gaps of SARA. I think that, as you know, New York is not yet actively engaged in SARA. Governor Cuomo has signed the legislation, but we haven't taken the next step needed to implement it for New York-based institutions. So I know a lot of you in this room are in that same situation where you're not SARA states, or kind of waiting in queue to become a SARA state eagerly, or you may be a SARA state. But I've found that a lot of people, from an institutional perspective, take the standpoint of, we're SARA, state authorization's over for us, we're good to go. And unfortunately, depending on the activity within your school, that may not be the case. So it is really important to be keenly aware of the gaps that Jeannie discussed in the beginning, plus some other more detailed gaps, because there are some tracking and thresholds that are involved with things that aren't covered in SARA. For example, it does cover non-classroom experiences or placements where students are on the ground in other states, but to that threshold of 10 students per location. So a lot of the programs that schools have might not be big enough to meet that threshold, especially in a given state you might have 10 students, but it's also per location that the student is engaged at, which is an important thing to know if you're trying to track where your students are going and what they're doing. But for a school like NYU, if our Stern School of Business has a relationship with a corporate entity and is sending cohorts of students to a specific business in the summer to engage, we're definitely going to surpass that threshold of 10. So it could very, very well be the case for your institution, and is the case for some states with NYU, that we do fall in, once we fall under SARA, we will have a tracking component that will be very important for us to monitor to make sure that we do maintain compliance in even SARA states. So we recognize that there very well could be a need for us to engage with the state that is a SARA member and go ahead and do extra compliance measures there when we have activity outside of the scope of what SARA covers. And just even maintaining our communication strategy within the institution to get our school liaisons aware of the fact that you've heard of this SARA reciprocity agreement. It is great specifically for your purely online programs, but there's a couple things you have to be aware of, especially for field placement coordinators that are doing those contractual engagements on behalf of the students going out into the field. So we've been able to kind of, obviously we're not delaying, we've been on the forefront, we've done robust research through SARA, the SARA website. Alan's been really helpful in speaking with us about what's covered, what's not, and how to kind of manage that or become prepared to manage that when New York institutions are eligible to participate. We've created a plan to close those gaps. We have some systems in place to track and monitor some of those gaps that do exist. And then we continue to communicate with our school liaisons at annual meetings and regular newsletters about those gaps so that they know what's coming and they know that it's the answer to some of our problems, but also will create some reporting requirements that they're going to have to adhere to if we want to continue to remain compliant nationwide. So I think the secret to success for NYU, even though we haven't yet flipped the light switch to be able to plunge in and join SARA, is just being very proactive. You know, we've followed it in the news just like everybody here has, and every time something new comes up or a conversation started, we're definitely engaged in reading and disseminating that, but disseminating it within our university with advisement to let schools know that we're on top of it, we're aware of it, because the last thing I want is for one of my School of Nursing or School of Medicine or School of Law liaisons to send me an article before I've read it or said anything about it. So that's how we manage it at NYU, and if anybody from an institution wants to speak more about some tips and tricks, it's definitely a complex thing to manage and communicate, but it's really important.
Thanks, Brianna. Moving on to the federal, and this is not so much, the federal overlay is not so much about SARA gaps, but inconsistencies that one sees between SARA and between the federal rules that are important for institutions to be aware of so that they don't become traps for you. Just starting at the beginning, I think everybody knows the story of the federal distance education rule back in 2010, the Program Integrity Rule Package, where the department added at the last minute a rule that states would need to be able to demonstrate as a condition to eligibility that they had whatever the authorization was that their state required and produce it to the secretary. So that was then thrown out in the Abscu v. Duncan litigation. Fast forward a couple of years, the department initiated a negotiated rulemaking and tried out a different state authorization rule that was much more far-reaching. And it was not well received, there was not consensus, and the department pulled it back. We've not heard much more about it, and it seems to me likely that they won't proceed at all. part of the thinking, of course, was to let SARA proceed and then to see whether there was a need for such a rule. The department, however, has not said one way or the other whether they would introduce a rule, and they certainly could. It's possible also that this could come up in the HEA process. It actually did last year with the Republican staffers on the Help Committee wanted to add something in the HEA that would prevent such a rule from coming back. And the Democrats balked at that, and nothing really happened. But I wouldn't be surprised if it comes up again. The good news from all of this history is that the department apparently accepts SARA participation as evidence of authorization. But the bad news for institutions is that this department staff still seems to think that that institutions are required to comply with their state's laws regarding distance education. As after the court case, they restated this in their Dear Colleague. And what's very odd to me is that the vacated rule is actually still in the Code of Federal Regulations after 4 years. The issue comes up, in my experience, in the recertification process, particularly with for-profits, where the department will challenge whether an institution has all of the consents and approvals that it needs. I always counsel clients for that reason not to mess around with it. It's a condition of Title IV eligibility, so you should get your approvals whether the federal government requires it or not. There are some other federal rules that are often overlooked, and these came out as part of the Program Integrity Package back in 2010. There's a rule that institutions have to disclose to students in all states, not just the ones where you're licensed, what the complaint agency is. And it also, as part of that rule, it says you have to keep a record of that's available on request showing where you have your approvals. And the department has indicated that the complaint agencies need to be posted on your website. The department's federal misrepresentation rule, which again was changed in 2010, is really quite broad. It was mainly upheld by the courts in the ABSCU litigation in 2012. And it specifically references as a form of substantial misrepresentation, a misrepresentation around authorization or accreditation of a program. Meanwhile, creditors and states have added their own misrepresentation requirements. It's also a part of SARA, of course, but you see HLC, for example, added a lot of new requirements around misrepresentation a couple of years ago. The Massachusetts AG somewhat notoriously put together a whole new set of misrepresentation rules in Massachusetts, some of which were thrown out as unconstitutional. So you have this kind of plethora of misrepresentation rules, and the state AGs and the FTC in particular are quite active in going particularly after for-profit schools under this theory. The danger to schools ultimately is that the department can then use a sanction by one of these other agencies or a state agency as the basis for a federal misrepresentation fine or conceivably even the loss of Title IV. So SARA or not, the new normal is that institutions really need to be 100% accurate in their disclosure of their authorizations. Gainful employment, you heard a little bit about this from Sharon, and there'll be a lot more about it tomorrow, but there's one provision I just wanted to bring to your attention, in that, and this one came together at about the time the department was looking at doing a new state authorization rule, and that was that institutions need to certify that their programs lead to licensure in each state in which they're required to be authorized. But since the federal distance rule was never completed, it creates this ambiguity, which is not really resolved by SARA, as to what happens if and this is typically the case, there's clinical programs in a state. And that unlike SARA, the federal mandate here is an affirmative disclosure, whereas in SARA it's a little bit different. You can meet the SARA requirements by simply saying that you don't have the information, whereas the feds at least are trying to mandate that you say affirmatively whether you meet it or not. There's a new template. I think it's probably going to take a little longer than this to get this together because it's very difficult. It takes a lot of time and trouble to figure out these professional licensure rules. And then there's more because the defense to repayment rulemaking, negotiated rulemaking just was completed and it honestly was a bit of a circus. And what seems to be on the table is that a alleged misconduct by an institution, even under state law, can entitle students potentially to refunds and enable the department to go after the schools for those Title IV amounts or result in new sanctions against schools. Now that rule has not been issued yet. I'm just generalizing a little bit based on what was proposed in the negotiated rulemaking. But this is on the theme of misrepresentation. It's a whole new a whole new area of danger for institutions from which they would not be protected merely by being a member of SARA. So let me turn it over to my friend Alan.
Is this one working okay? Yes, I think it is. I mean, we've talked a little bit this afternoon about not only the gaps that we talk about as SARA gaps, but these slight inconsistencies both inside the federal structure, inside SARA, inside even kind of what states currently do. And I think it's SARA ideally ought to fill some of those gaps to the extent that it can, but it's important that my own view is that SARA should not become, and none of us should think that it should become, a sort of large bureaucracy that's designed to slowly, amoeba-like, fill in every gap that it can find, and that it not expand indefinitely to sort of grab these things. There are functions that are federal functions that the feds need to do, and SARA needs to stick to its own knitting and do those things to the best that it can. Mike's comment about my lifelong desire to be a glorious science fiction writer and the intimate connection of that to the drafts I do for SARA. The fact is, in the early days of SARA, which are pretty much over at this point, I was asked more than once in the first 18 months of SARA's existence, aren't you just making that stuff up? And the answer is, yes, I'm making that stuff up because all of this is brand new. And somebody had to make it up, and that is to the extent that possible, what we were doing, we tried to link with existing federal and state laws so that there was a smoothness there. That is obviously, Bob Shireman has been running around California and New York boldly suggesting that SARA is imperfect. Well, can I see a show of hands of everyone out there who thinks that SARA is perfect? See that, Colonel? Colonel? No? Marshall doesn't think so either. Well, I think we all understand that it isn't. Sometimes the question of whether something is a gap or a feature depends on what it is you think it's designed to do to start with. And the licensing board's question is a good example of that. We were asked when we started SARA, would you please include coverage for these interstate licensing issues? And we said, do you think we are crazy? Because there was no possible way to start out with the general purpose SARA that we wanted to design and just sort of casually say, oh yeah, this'll, and oh, by the way, if you're participating in this, that covers interstate licensure for, nurses, teachers, psychologists. We'll just bring those all in. That'll be simple. Well, we would have been hanged at dawn if we had tried something like that. because the licensing profession, and I serve on a state licensing board in Oregon for teachers, and there's simply no way that professional boards would have had a very pleasant conversation with us, and I think we all knew that. I mean, one of the discussions lately has been, what exactly, what's going. I mean, Shireman has been talking about what's going on in New York, and since you're trapped up here and you're from New York, I will ask you what direction do you think the institutions want to go in New York? What's the goal there?
Yeah, New York has been very active, and I would say really for the past 2 years in pushing to get Governor Cuomo to begin to have conversations with SARA and to sign required legislation to move towards joining SARA. And Dr. Bob had mentioned in her last session the Vanderbilt study that they've spent $14 trillion on compliance efforts, and she had a good point. When they have a med school and all the other moving pieces and grant management that they have, it's not unrealistic that that's what they're spending. And I will say that NYU and a lot of other large schools in New York are similar. We spend a lot of money on compliance and red tape, and a lot of times it's hard to see where the quality control is in that, with applications and checks that are just pumped out that don't sometimes lack substance in terms of learning outcomes and quality. So I think for New York institutions for a long time, we've been looking for some reprieve so that we can reach students and have enrollments and continue to have our programs be viable and have enrollments for students that want quality education, but not have to spend so much and keep increasing tuition again and again for our students. Just where does it end? And at NYU, we have a big push towards affordability with our new president, Andrew Hamilton, this year. And for the first time in 20 years, we're seeing the lowest tuition increase, but we need to cut other places. And at what point does that cut end? So I think institutions in New York are ready for an answer. And the article that Shireman was quoted in, he mentioned, how did SARA get pushed through so quickly through legislation in 2015? It can't have any substance to it. It was thrown together. But for those of you who have been in the industry for years, I mean, 2007, 2008, 2009, when Paul Schiffman and a lot of others in the room who were beginning to form SARA ideas and foundations, I mean, SARA's been in the works for a long time, and a lot of very thoughtful policy leaders have been involved in it. So it wasn't just thrown together willy-nilly, and I think industry people know that, but the press who are attacking it and people who are just picking it up and want to talk about it, they're not digging deep enough. So there's definitely a difference between institutional knowledge and view of where we're going and what we need for affordability for our students and actualization of what's happening in conversations in the media.
Would any of you care to say anything about how New York law works right now for distance ed students?
Yeah, New York currently doesn't regulate distance ed enrollments for out-of-state institutions. So internally as a New York institution, we submit a format change request, and we have approval from our regional accreditor to provide distance ed formats. But for any institutions located outside of New York, they are not what we kind of refer to as a purely online regulator state. You can enroll students from New York with very little effort.
I think I'll close my comments just talking a little bit about...
Alan, I just wanted to comment on your last question now, because the Shireman critique assumes that the New York AG even cares whether New York authorizes purely online programs or not, and they don't. I mean, they have other consumer protection laws in New York, and if they think somebody's violated the law, they're going to go after them. And in fact, I think that's already happened when they settled up with CEC a few years ago over alleged misrepresentation of placement rates. It wasn't just the CEC ground schools in New York, it was also the online schools. So there's nothing in SARA that really keeps the California AG and the New York AG from jumping in if they feel like there's a reason to, because their jurisdiction is quite different. The other thing about the critique that I think is a little off base is that while it's true that New York doesn't require authorization for the purely online programs, it does require authorization for a lot of other programs, like we were just talking about in our presentation. So there's a lot that goes on in New York that, even if it has an online component, it still requires licensure and is closely regulated. So it's really only, that statement really only applies to the pure online degree programs, which is really a subset of what is at issue.
The only other thing I wanted to add, not about that, but there are gaps in SARA that are there on purpose and probably ought to stay that way. There are gaps in SARA that none of us have even noticed yet, and the day will come when we notice them. And there are some things we know about that we are working toward fixing to the best of our ability. But keep in mind that SARA, in its early stages, Marshall and I and the regional directors just sort of built it from the ground up. But now at this point, there are around 800 schools that are participating in SARA, and that number is going to be much bigger by next year. And there are 36 states right now, and that number is going to be much bigger by this fall by quite a bit. At this point, SARA exists to meet the needs of the states that sort of operate it through the regional compacts. And there is a process through which any gaps, if you will, that need to be fixed can be fixed. Any state that's a member can propose, any of its schools can have their state propose that something be changed. It goes through a standard process just to make sure that we don't end up with a gap is one thing, a sinkhole is something else. When we find a gap that needs to be fixed, we want to fix that before it turns into a sinkhole. So, thank you.